you'll see on the next slide, the structure of my talk maybe reflects my own interest, because I'm going to talk about the concept of international protection first, actually. And I know in the PROTECT project, this is your framework and preoccupation. But given that I think it's an underdeveloped concept, I think it's worth thinking about what are the gaps in the concept of international protection and actually thinking about its utility. And then bring in a discussion that I think is really important, because I agree with your premise that the bindingness or non-bindingness of the compacts isn't really the most interesting question. We should be thinking about their effectiveness. But I think when we think about effectiveness in general, I wanted to just raise the fact that there's a very sophisticated scholarship on effectiveness of human rights commitments, and especially that because international protection is a concept rooted in international human rights law, not exclusively, but predominantly. That really, it's always puzzled me why refugee scholars and lawyers don't pay more attention to this effectiveness scholarship. And then use that to reflect a little bit on the compact, but really they're throwing back questions about how effective the compact can become, is really a hostage to fortune, but open up some of the issues I think are going to be important. I'm conscious I have half an hour, so I'm going to move through the slides pretty quickly, and please feel free to remind me when time is short. So when you asked me to reflect on an international protection regime, I thought, well, we have a displacement regime in a way, because when UNHCR, for example, reminds us of the growing population of displaced people in the world, it's mainly talking about IDPs. And so IDPs make up, this very large bulk of the world's displaced population. Of course, they're not addressed by the compacts, but I'm going to talk about them a little bit today. And then we have, the ultimate protracted refugee situation, the situation of Palestine refugees. And then we have a figure of refugees under UNHCR's mandate, and an intriguing new category that UNHCR now counts, which are Venezuelans displaced abroad. I'll talk about this a little bit more, that why they're not classified as asylum seekers or refugees. It's partly to do with the fact that the Venezuelan response is a jointly headed mission by UNHCR and IOM. So the blurring of the refugee migrant line into this general category, who may or may not be international protection beneficiaries. I think that's not entirely clear either. I think it's a really intriguing one. But one of the questions I want to ask about international protection on the next slide is, what does it add to what we're talking about simply a global refugee regime? Because I am always mindful that the proliferation of labels can be useful, but it can also be pointless or counterproductive, or it might even just raise sort of additional new challenges. So my thoughts are really drawing on a couple of papers, some of which are published, and one which is forthcoming, which was a background paper, which Angela Sherwood was the lead author on, which we prepared as a background paper for UNHCR for its report, which is coming out, which isn't called the State of the World's Refugees this time, it's called the State of the World's Forcibly Displaced Persons, which is interesting. So to move on to the substance in relation to international protection on the next slide, I wanted to raise a couple of questions about what's missing when we talk about international protection. Yeah, on that next slide. We know that it's a wider concept than refugee protection. And so it's attractive because it seems to cut across the refugee migrant binary, which isn't always a helpful one. When we look at UNHCR's definition, it's about those who are displaced still outside of their own country. So we still have a big question about IDPs and their protection needs. But it takes a very broad notion. But the hallmark is still somebody protected against refoulement, somebody who is who cannot return to their own country because of the risks they will face there. And I want to suggest, as you'll see on the next slide, that this rootedness and non-refoulement is part of the strength of the concept, but also part of its weakness. So I think there are three aspects that are underdeveloped. And I think in this, I'm very much ad idem with the PROTECT project. So in some ways, this reflects, I think, where you were going with the concept too. But the crucial question remains access. So any concept rooted in non-refoulement is about protection against return. So you need to be in the place that is safe for that to be a meaningful protection. So access, I think, remains the acute challenge for any regime which is about protecting people who need to flee. The aspect I wanted to talk about today really does reflect the work in the Refugee project, because one strand of that project is called Recognizing Refugees. It's about to bear fruit in a lot of country reports and a lot of material which aren't yet available, but should be in the next while if you want to look at the Refugee website. But we've been studying recognition processes a lot. So however you draw the line between refugee and migrant, or between international protection beneficiary and those not entitled to international protection, for me, just as important, if not more, than the legal definitions that are going to be operationalized are the institutions and the modes of decision-making around that question. And then I agree very much with PROTECT and with Jürgen's opening comment that the content of international protection really needs fleshing out. And there we might really want to ask ourselves, the Refugee Convention has a rights catalogue and also has a framework for the acquisition of rights over time in host countries. And do we lose something if we don't focus on that particular rights catalogue? So turning to the next slide. When I think about access, of course, all of the move towards broadening out countries of resettlement, complementary pathways, humanitarian visas, all of that work seems really important. On the one hand, you could say it's insufficiently normatively driven, because there is a human right to leave any country, and it's very rarely invoked or enforced. And this might be an area actually where international human rights law and its traditional enforcement apparatus could be more frequently invoked. There's a lot of really good scholarship now on the right to leave, including a great doctorate I supervised in Oxford by Emily MacDonald. The scholarship I've just set out on the slide, but maybe there is work here, where human rights law has an underexplored right. Obviously, it's not an absolute right, but I think a lot of the practices of containment, which are the hallmark of the global refugee regime, may actually be open to challenge. Then you'll see on the next slide about recognition practices. I mean, here I could talk indefinitely, but just to open up the question. So who decides who is a refugee, or indeed international protection beneficiary, if we want to widen out the scope of concern? Well, UNHCR in 50 to 60 countries. The fact that we never have a stable number tells you how much flux there can be, because UNHCR sometimes is the decision maker, sometimes is a joint decision maker. There are lots of practices in countries where states take back the function, as has recently happened in Turkey and Kenya, and in some cases hand it back again. So the politics of who is the decision maker is part of the global regime. We know that how you decide makes a difference about who is included, and states can decide to include everyone. So Turkey offers temporary protection, temporary, but it's actually quite relatively stable, to all Syrians. Prima facie practices in Africa include usually all those of the nationality who flee, and then Europe tends to prefer more individualized practices, but of course responded to the Balkan Wars also with mass protection for those fleeing. And also one could say states like Germany in 2015 de facto offered a form of group protection for Syrians, at least in terms of the way the procedures were applied. But obviously how you recognize makes a huge difference to who is included. There's been a suggestion that the way we're seeing the Venezuelan crisis unfolding with very diverse responses across states in Latin America, it's mainly to do with the politics of those individual countries, obviously, but the fact that you don't have established mechanisms for group recognition in Latin America is one of the reasons why I think sometimes, or at least it's been suggested by Felina Freire and her co-authors, that might be partly why you see, instead of like mass recognition of Venezuelans under the Cartagena definition, instead states like, say, for example, Colombia just offering Venezuelans a different status, actually a very secure one with a 10-year residence permit and work rights. Really quite extraordinary when we think that regularization in Europe of, is usually a very weak status. I think what motivated me in the RefMig project at the beginning to think about recognition practices is just what I see as the pathologies of the European highly individualized, highly juridified, highly judicialized practices that don't deliver protection very often. And I think you can see that with the constant protection lottery and recognition rates. And also what I would term very often the fact that the rejected refugee is the rejected asylum seeker, who's sometimes called a failed asylum seeker, is in many intents and purposes, a nearly refugee. The grounds of rejection can be so fine that I just think ethically and politically, that lots of rejected asylum seekers have protection needs. And of course, you see that then manifesting itself in insecure statuses like Duldungs in Germany, Kettenduldung, and other manifestations of the fact that protection needs are not recognized appropriately in individualized asylum systems. So when I think about the international protection regime on the next slide, and what would it mean to add this extra layer on top of refugiehood? I think it depends in different regions. What would it mean to add an overarching concept of international protection in Europe, where we already have two statuses and national humanitarian statuses as well in the EU law specifically? I think one of the lessons in Europe too that we see is that if you have multiple statuses with different rights attaching to them, there's a bureaucratic dynamic of siphoning individuals into weaker statuses with weaker rights attaching to them, notwithstanding the fact that in law, obviously, subsidiary protection is meant to be subsidiary to refugee protection, but we know very often the practices, again, Germany is an exemplar, but only one of a very clear situation where at a certain point in time, even Syrians were being deemed to be not convention refugees, but subsidiary protection beneficiaries because of the different family reunification rates attaching. And that was made quite overt and led to a lot of successful legal appeals. So again, some of the pathologies of the very individualized process. What would it mean in Latin America to add international protection as an overarching framework on top of, the binding 51 Convention and the non-binding Cartagena? Non-binding Cartagena is a very interesting case study for effectiveness because, of course, it's implemented in the national laws of most countries, but that doesn't mean it's been operationalized. It doesn't mean it's been applied, even if we take the Venezuelan context as a current litmus test. So I think when we look in the African context, obviously one of the interesting facets is that you have a binding, wider regional definition. And at least legally, I think it's quite clear that convention refugees and those falling under the expanded regional definitions are to get the same rights. I think the institutional practices across Africa do show this bifurcation with this tendency to associate the expanded definition with prima facie recognition, but that also varies very much. But I think there's a real lack of legibility about the prima facie practices. And in fact, I'm really happy to be able to use some of the resources of the RefMig project to try to get a mapping of the past 20 years of prima facie practices in Africa, because there isn't one to date. But there's a lot can be learned, certainly from this, the way that a wider refugee definition has been operationalized. But states aren't that keen to completely widen it. So there's quite a lot of resistance from African states to including climate and disaster displaced persons under the African regional definition, although doctrinally that's quite a sensible move. I also think on that point that the work of the Nansen Initiative in tracking state responses to disaster displacement and also framing slow onset disasters within their mandate are two very canny moves that, again, that non-binding process made. I think Walter Kalin, who was also instrumental in the guiding principles on IDPs, is really one of the most ultimately savvy norm entrepreneurs in this field, and his work can really be studied to see how apparently very dry and doctrinal work can actually be massively influential and transformative. And then what would we say about the countries where most of the world's refugees are, which haven't ratified the 51 Convention? So the major host countries like Lebanon, Jordan, Pakistan, Iran, obviously so salient when we think about the current Afghan situation. What would it add to have an overarching concept of international protection? I think the question is, it's not clear to me at all. I mean, these countries host large numbers of refugees. One of the biggest variables is the extent to which UNHCR is a major actor or not. So there, I think Turkey is really, taking back its own asylum system and not having UNHCR as a major player, either operationally or from a status determination point of view, is really different. But there's, I think that aspect of the global refugee regime is really understudied. And obviously some scholars are really giving it appropriate attention now, like Maya Janmeyer and her team in Oslo. But this was really just to sum up what I think are some questions about broadening out labels without thinking enough about recognition practices and some of the potential pitfalls. And I often like to go back to a very early piece that Thomas Bijkeboer wrote when the notion of subsidiary protection was taking shape in European legislation. And his point was very simple, saying, well, if Europe had implemented the refugee definition properly, we never would have needed subsidiary protection. So often these apparently expansive moves are actually just about proliferation of labels and not really addressing the core protection needs appropriately in the first place. So turning to the next slide, I wanted to just briefly think a little bit about the third dimension, about content. And I think there the shift, again, normatively, but then very much operationally, that's missing is ensuring that if protection is rooted in non-refoulement, it translates into security of residence. In some ways, Germany might be an exemplar of bad practice with Duldungs and extremely precarious semi-legality for people who can't be returned. But that predicament is really quite widely shared in different manifestations, but in different parts of the world. In fact, very often, I think in states like, let's say, Lebanon, which we've studied a bit in the Refugee project, even those who are recognized as refugees by UNHCR don't automatically or even at all actually have security of residence or a legal residence permit under domestic law. So they really exist in this sort of strange netherworld where you have, for the point of view of the externally, for Lebanon, these are refugees. They are counted as such. Lebanon receives a lot of international aid and funding for them. But that status is not meaningful domestically, which means people are vulnerable to detention. Their insecurity of residence translates into a whole lot of other disabilities, I think, that people don't often really fully understand when they look at the fact that these people are counted as refugees by UNHCR. So security of residence as a sort of as a right that can quite easily be developed from international human rights law, but isn't clearly instantiated, I think is quite important. Just on the next slide then, I need to see it to remember what I was thinking. Yeah, so I mean, in terms of content, we could expand, and I know today we're going to have presentations on social rights. So I didn't want to talk too much about content, but I think, the idea of security of residence as a move, a normative move, I think is quite important. So then shifting to the question of effectiveness, and I really just wanted to point out, and here I'm a consumer, a fan of this scholarship rather than a producer of it, but this is an area where you have a very sophisticated empirical scholarship asking the question, why do states commit to human rights treaties? Why do states comply with them, or under what conditions do they comply with them? What practices in terms of encouraging states to comply work, and which practices are counterproductive? And then a much wider discussion about whether human rights commitments are effective in the sense of whether they're materially beneficial for the enjoyment of human rights. And those three questions are separate and quite distinct ones. So these are the three that I thought are my favorites. I mean, I would say this scholarship, I mean, in a way, when did it start? But one sort of very early move was Una Hathaway's work, which really set out a very audacious claim that human rights treaties don't just make no difference, but in fact, they make a negative difference. right? That states ratify the Convention Against Torture and then they torture more. So this really should be, an area of scholarship that those who, want to work seriously in human rights should at least be aware of. And then there were a number of very sophisticated ripostes. I think Beth Simmons' work mobilizing for human rights really stands out. And I haven't included the cynical or more cynical, skeptical voices about human rights here, like Samuel Moyne, and others. And Catherine Sicking's work really is a distillation of a lot of her previous and other previous empirical work on the topic. And I think thinking of Sicking, I think one point which has particular resonance when I think about the European situation is that her work makes a lot of demonstrates, particularly from the Latin American context, but not exclusively, that one way that human rights become more effective is if they're combined with measures to end impunity. And so she studied international criminal and domestic criminal trials against perpetrators of human rights violations. And this was something that I tried to explore a little bit with Itamar Mann in a special issue of the German Law Journal last year. But if you think, as I do, that Europe is a site of massive human rights violations committed in the name of migration control, then the question of accountability, not only for those human rights violations per se, but for the international crimes that are committed in the name of migration control is, I think, a serious legal question. And based on Sicking, you would say, is part of what would make the human rights commitments more effective, would be the ending of impunity for those violations. Grania de Burca's book, like Simmons, and indeed all of Sicking's work too, they all really focus on how domestication of commitments is important, institutions matter, but so does mobilization. So, supporting civil society actors, transnational advocacy networks, and really asking quite sophisticated questions about what works and what doesn't work. And Sickig in particular really highlighting the fact that the evidence base is really crucial, because often we're comparing with an ideal, and in her work really it's about establishing a baseline. And she's also very, I think, sophisticated around the issue of invisible violations. That as soon as you start to try to understand a phenomenon, you make it visible. So that applies with domestic violence, but it also applies, for example, with the whole phenomenon of IDPs. We didn't ever count them before. So this constant sort of refrain about, we've never had so many displaced people in the world is really hard to take, frankly, because, we only started counting IDPs about 20 years ago. And I think, historians of displacement find that claim that the world has never had so many displaced people really, really hard to take, frankly. And it becomes paralyzing in political discourse, because it's often feeding into this imaginary vision of Europe in particular under siege by unprecedented numbers of asylum seekers and refugees, which is simply untrue to anybody who has a basic understanding of 20th century European history. Anyway, moving on from this scholarship, I think what's always struck me as interesting, and here I'm not going to deliver any insights, I'm going to deliver an invitation, is where's the effectiveness scholarship in international refugee law? There's a couple, maybe one or two small pieces, but there's no overarching scholarship on asking the question, what's the impact of ratifying the Refugee Convention? Although you have scholarship on that topic about CEDAW, about CAT, about the ICPR. And it's puzzling, given the fact that there's so many non-signatory states that are crucial in the global refugee regime. And really, UNHCR doesn't encourage them to ratify anymore. As I mentioned, Maya Yanmir is going to look at this in her Beyond project. And there were some insights just peppered across the Oxford Handbook. One in Osamu Arakaki and Lily Song's chapter on East Asia, where they talked a little bit about strategic ratification. I found the description of practice, what had happened in Korea, was really fascinating, where there was a really successful civil society campaign, which led to the creation of domestic asylum processes, and then no refugees recognized. And very interesting mechanisms put in place to make it both physically and procedurally quite difficult to gain access to the procedures. So I think in some ways states look at European inadmissibility practices, and they learn those lessons very quickly. So if we don't really have an effectiveness scholarship about international refugee law, this really leads me to say, well, what do we know about what works? I mean, we could be extremely modest and say, well, we don't know very much. I mean, there is actually a bit of an effectiveness. Actually, just going back to that slide, I mean, I do think Lamis Abdelati's recent book is a really, really significant addition to the literature. We interviewed her in RefMake on the website, so you can see what the book is about, but reading it would be even better. But that goes some way to explaining at least some of the diverse responses of states to refugees. And also she deals with this question of why states would delegate RSD to UNHCR or not. So it's also really important from that point of view. So on the next slide then, and I'm getting towards a conclusion about the compacts. We know a bit about implementation of the guiding principles of IDPs. And again, that reaffirms the PROTECT.project's premise that binding, non-binding isn't the key thing. But I think the difference maybe between the IDP guiding principles and the compacts is that the IDP guiding principles were a really skillful legal distillation. And they did, in some respects, really push and entail a very expansive and progressive development of certain human rights. And David Cantor has traced this really nicely, how then those particular principles got taken up by human rights bodies and were a catalyst for a progressive development of human rights. And of course, they've hardened in the sense that in Africa, you have a binding, widely ratified IDP convention now and a model law on which has proven to be quite effective. And that's traced in Romola Adiola and Phil Orchard's piece. So some of that scholarship can be instructive for the compacts, but I think when we look at the compacts, we have a sort of a different issue in the Global Compact on Migration in particular. Just turning to the next slide. Yeah, in fact, I might skip this one because I could talk about non-refoulement for too long and I'm conscious of time. And this, I would just say, I'll talk about the right to work in questions, but we have some reflections on this and coming up in a webinar about how to make the right to work effective. I think I should move on to the compact now. So when we look at the compact, I think I have 3 questions and I'm sure they're on your mind too, those of you who are studying the compacts or indeed working within the framework of trying to make them effective. The first one is just whether the Global Compact on Migration sets clear aims and targets. So it certainly isn't framed as a mechanism that has targets explicitly in it. But when I think about its overarching aim, I think back often to a think piece that Jürgen Carling wrote saying, this idea of safe, orderly, blah, blah, migration really can be read in 2 very different ways. It can be read in terms of, repressing mobility rather than enabling it. There's no clear commitment in it to liberalize migration. I mean, you can read it as requiring greater migration and mobility opportunities, but that's not necessarily how it has to be read. And it's certainly not how states read it. Then the question, does it set clear norms? You could say beyond what's in international human rights and refugee law. I don't think it goes beyond very often. I think it captures international human rights law, but not always. And I think this is captured very well in Vincent Chattai's kaleidoscope analogy. It refracts international human rights law. And on some issues, it gets it right or kind of on the progressive side of interpreting the human rights obligations, but not always. So that for me is a real question in terms of its efficacy. And then of course it's going to come to life within softer processes. It may at some point come to life in litigation or by invoking it before UN treaty bodies or other adjudicators, but it's mainly going to have a life in these softer mechanisms, and they can be effective. Peer review and reporting on some issues certainly does change state behavior, but not always. And I think that's the really crucial question for the future. So what do we know so far about how the Global Compact is working, let's say? So if we took an example on the next slide of one of the commitments in the, so basically what I was saying about aims is really how I don't think the compact can only be read about increasing migration opportunities. It can also be read about, allowing states to define as much immigration as they want as irregular, and seeking to avoid and repress, even repel irregular migration. I think when I asked the question about norms, one example that I wanted to work on a little bit was the detention example, and I know we're going to talk about that a little more. But as you can see on the next slide, I think it's fair to say that the detention provision of the Global Compact, and here I'm citing just a guess, but I agree, is pretty good. The last resort language, it captures fairly well what international human rights law requires. And they suggest that this will mean that it's a powerful tool to end the human rights abuse of excessive immigration detention. And there the question is, well, really? I mean, what we've seen at the EU level is a pact which seeks to normalize immigration detention more, I think, arguably. And EU law, to my mind, has always generated additional grounds for detention. And then we would say, well, if you want to enforce your right to liberty to protect yourself against arbitrary detention, you have, depending on the region of the world you find yourself in, but lots of different fora to try to enforce that. But we've had certainly some very worrying signals from the European Court of Human Rights on the topic of immigration detention. I mean, with a little bit of a correction, but quite shockingly for those of you who are not from Europe, in a Grand Chamber ruling of the European Court of Human Rights, they accepted arguments from Hungary that its confinement of individuals in border transit zones, which are camp-like carceral structures, was not detention at all, because people were free to leave. And leaving meant not staying in Hungary to have your protection claim assessed and walking straight into Serbia in the particular fact constellation. Now, the court sort of resiled a little bit from that fact, but it shows the fact that, in Europe, with all of its human rights institutions and judicial enforcement, even the question of what is detention becomes the focus for legal contestation. So I think it's clear to say on some issues, the compacts reiterate and restate human rights commitments, or in some cases even international labor law commitments in a helpful way, but not always. So I'm not sure, this to me throws up an important question. And then the final point that I wanted to conclude on is just the question about the mechanisms. So here, I'm throwing it really back to the PROTECT.project and other scholars who are going to try to focus on this more systematically. But what we have is very weak review mechanisms, but of course they can become stronger, they can become more robust, and that's really the work that has to be done. I'll confess, and as somebody who works, exclusively in the field of asylum and migration, I was unaware that we had a regional European review of European commitments under the Compact. So that may be a mea culpa on my own part, or tell you something about how much attention that regional review attracted. I just have a couple of observations about it on the next slide. I know there are scholars who have been following the Compact, and so kudos to Elspeth and her team and the RLI blogs they've been putting together. So I consume that. I was really struck by Danae Agnelli's observation that Greece chose not to even mention the issue of missing migrants, even though Objective 8 in the Compact is again expressed in quite strong terms. So this high selectivity about what states choose to report on. I also read a very interesting but depressing blog about the Dutch approach to the Compact, where they've just basically said everything we do is fine, full stop, I gather. It was in Dutch, so I may be slightly oversimplifying. So the regional review, again, whether it was efficacious, I just have no idea, but it's certainly the case that states report as they wish. And if it's to be effective, I think civil society shadow reporting and a great deal more attention and scrutiny would have to be obviously a key feature of the process. And that's really the point on which I wanted to conclude. Obviously, what's coming down the line in 2022, as you'll see on the next slide, is this international review. And I think a lot is up for grabs. We have had a resolution setting up the main aspects of that. But, I don't feel in any position to comment on, whether that's going to be effective or, and how would you even measure it, because states will report as they wish. I think civil society in this field is constantly overstretched. And so if I were a civil society organization, a migrant rights organization, working really anywhere in the world, I'd be asking myself, well, am I going to support litigation? Am I going to support work before the UN treaty bodies, which are now really the main forum for non-refoulement? Am I going to lobby bilaterally with donors for a bilateral process to try to leverage better rights within my country? And I don't really know how I would weigh up all those various options, but it's certainly not to me obvious that the compacts are going to be the most effective forum for leveraging for positive change on migrant or refugee rights, for that matter. Although I'm very open to being corrected on that. So thank you for your attention.